Hi, my name is Erica Carter, and I'm a juror. My decision is I side with the plaintiff. Now, the case was that the plaintiff is complaining that the defendant released medical information without the proper procedure and proper notifications to allow the plaintiff's time to get anything in order or to request order for protection of their rights. So once again, like I said, my decision is to side with the plaintiff. We have what we call HIPAA, which the hospital falls under, is a HIPAA protected hospital. A hospital, which HIPAA stands for Health Insurance Probability and Accountability Act, a U.S. law designed to provide privacy standards to protect patients' medical records and other health information provided to health plans, doctors, hospitals, and other healthcare providers. Now, with HIPAA, there are two things: a court order. A court order is a healthcare provider or health plan may share your protected information. A court order is issued by the judge, so they can immediately, without notifying the patient, they can share your information. However, the provider or plan may only disclose the information specifically described on the order. So whatever is written on that court order is the only thing that the healthcare provider can give to whoever asked for it, because it's signed by the judge, and that therefore it does not qualify the notification of the patient. Now, in this case, it was a subpoena. A subpoena is issued by someone other than a judge. So that could be, a county clerk or attorney in a case. It could be on either side of the case, the plaintiff or the defendant side. And they could be using it for, anything in a court case, anything. And once again, a subpoena is different from a court order. A HIPAA-covered provider or plan may disclose information to a party issuing a subpoena only if the notification requirements of the privacy rule are met. Before responding to the subpoena, the provider or plan should receive evidence that there was reasonable efforts to 1. Notify the person who is the subject of the information about the request so the person has a chance to object the disclosure, or 2. Seek a qualified protective order for the information from the court. Now, the plaintiff stated that she was not notified, and because it was subpoena, the defendant was in the wrong. Now, it seems like this hospital needs more training, because that is the number one. You cannot violate HIPAA. It could put the hospital at, in a lawsuit. It could do a lot of damage to their facility. So, once again, the plaintiff was not given the opportunity to be notified. Her medical records were just released. So anything that she may have happened in the past that she didn't want nobody to know, very personal information was now shared with whoever got that information or wanted that information from her. She was not able to obtain a protective order, which, could be, if it's in case of like a case or anything, it could be overruled by a court order. We don't know, because her rights were taken from her as a patient of that hospital. And as a patient of the hospital, you should feel secure, you should feel safe. That is why the HIPAA was made in the beginning. It is to make sure that every patient who goes into a facility has that knowledge, that feeling of safety, that this is between me and my doctor. I can tell him things, I can be honest, and he's not going to share it with the world unless a judge orders him to share it with the world. And at that point, there's nothing I can do about it. But this poor woman's rights were violated, and she should not have had to be traumatized by whoever used the subpoena finding out her information as it was. She should have been able and given time to find out why these people wanted her information, what they were going to do with her health information. But instead, the hospital victimized her and took away her rights. So once again, my decision is to side with the plaintiff. Thank you, and once again, my name is Erica Carter.